Thanks for the opportunity to speak today on this rather critical matter and neglected matter of justice for people with intellectual disabilities and within the criminal justice system. May I pay my respects to the traditional owners of the land on which we meet today, the Jagera tribal nation south of the Brisbane River and the Turrbal tribal nation north of the Brisbane River. I would also like to acknowledge elders past, present and the future. And additionally, thanks to the organisers of today's conference, the Endeavour Foundation, for inviting the Anti-Discrimination Commission, Queensland, to address this fundamental human rights issue, people with intellectual disability and those with impaired capacity who are overrepresented as both victims of crime and as suspects, defendants and offenders in the criminal justice system. I propose to talk briefly about human rights and disability, the latest developments. I would like to shape this talk to consider the broader policy paradigms, frameworks of the social model concept that impairment is part of the human condition and the failure of public policy to recognise the human rights of people with disabilities has led to structural discrimination and structural violence. As we know, the Convention on the Rights of People with Disabilities, the CRPD, along with other thematic conventions, create no new human rights, rather present them in a way that is relevant to the thematic group. This is the first time a convention, the CRPD, has been developed where the articles integrate all the covenants and the article titles reflect or contextualise human rights as they are experienced in everyday life. For example, Article 19, community living, which is derived primarily from Article 12 of the International Covenant on Civil and Political Rights, liberty. He shall choose where he lives and with whom he lives. Statistics demonstrate when we talk about vulnerable people who are homeless, they are predominantly people with intellectual and cognitive impairment or mental illness or are Indigenous, and perhaps the individual could have all three attributes. Additionally, the data is compelling when it comes to women with intellectual disability as victims of crime. One of the greatest challenges for the prevention of crimes against persons with disability is the general failure of the community and social service and law enforcement agencies to characterise illegal conduct towards persons with disability as criminal behaviour. Disabled by the system, examples of structural violence. In 2012, an Indigenous man named Marlon Noble was released under strenuous conditions from the Western Australia prison. Mr. Noble, who has a cognitive impairment, had been charged with sexual assault, but having been found unfit to be tried, then remained in prison without being convicted of any crime. He was there for 10 long years before it was decided to let him out. I wish I could say this was an isolated case. This audience, however, will know of too many similar examples. One such example is a young Indigenous Queenslander named Gray, plied with marijuana from a young age to control the manifestations of an intellectual disability. Gray committed sexual assault aged nearly 18. No agency, however, would assume responsibility. Disability services claiming his behaviour stemmed from the marijuana. Child safety pointing to his impending adulthood, and mental health to the absence of mental illness. Nevertheless, Gray remains in a secure mental health unit. No agency prepared to fund the counselling he needs for release. Gray's disability is what prevents him from understanding his situation, but the structures that surround him are what keep him there. Meanwhile, in prison for sexual assault, David's acquired brain injury excluded him from the criteria of a rehabilitation program, placed retrospectively under Queensland's serial sex offender legislation. Decisions regarding David's future ultimately rest with the Attorney General. David looks destined to remain institutionalised, not because he is a kind of offender necessarily contemplated by legislation, but because he is unequipped to navigate the system. Myriad stories like this exist, as this audience will know. Stories of recurrent failure of public agencies, of people falling through the service delivery cracks, of marginalisation compounded rather than alleviated by the state's response. In these stories, individuals are hostage to their perceived lack of capacity, unable to access mainstream services, yet deemed in their own form of catch-22, ineligible for available supports. In this way, the lived experience of disability becomes less about actual impairment and more about the obstacles that stand in its way. Graham Innes, the Federal Disability Discrimination Commissioner, told a Federal Parliament Joint Standing Committee on Migration, treatment of disability, in many cases, it is not the disability which is the cause of the problem, but rather the way that society has constructed itself. This analysis is echoed in the concept of structural violence, a term used to describe the way in which society's organisation can entrench rather than eradicate disadvantage and unmet need. A meaningful approach to disability, increasingly being adopted, therefore acknowledges it is because of communal structures rather than actual impairment that people face discrimination, violence and neglect. Reconstructing impairment and the law. This is a challenge that lies before those who work every day to dismantle the barriers and advocate for people with intellectual disabilities and cognitive impairment to be treated equally before the law and have equal access to justice. Witnessing, as you do, the way the legal framework can prevent rather than facilitate access. Today I wish to explore how we can all continue to employ this more meaningful approach to disability for the benefit of the communities we serve. Adopting these principles at a global level, the CRPD was certainly an important step forward. Recognising disability as an evolving concept that results from the interaction between persons with impairments and attitudinal and environmental barriers. Representing the first time that all international human rights covenants had been brought together under one umbrella, the CRPD emphasises the obligation of the state to take a positive approach to rights, to protect people rather than just refrain from discriminating against them. It is useful, therefore, to bring its considerations to bear when examining the intersection of disability and the law. A site where, as the stories touched on earlier, remind us people with disability are significantly overrepresented. Often, of course, it is part of a collection of attributes that put people at risk. It being no coincidence, these groups are more broadly overrepresented in our courts. People who are homeless or Indigenous or who have an intellectual disability, cognitive impairment or mental illness are statistically overrepresented. Also, those most vulnerable to human rights violations. The convergence of multiple forms of disadvantage can be a powerful cocktail. Structural barriers propelling a person with cognitive impairment into homelessness, or a homeless person into a deteriorating mental health. We could be forgiven for assuming that in such a case, multiple needs might be met with multiple support options. Yet too often, it seems the opposite is true. Individuals handballed from one agency to another, with few equipped or prepared to respond to any complexity, with no right to treatment acknowledged, and homelessness not recognised as a protected attribute under any Australian legislation. Vulnerability is entrenched for those already on the margins. As the 2009 report, Disabled Justice, observed, it is the Queensland justice system that disables persons with impairments, that interact with it. Their experiences, not the absolute result of impairment, but of social institutional systems that have failed to accommodate impairment as an ordinary incident of human diversity. We need responses that recognise this diversity, that can cope with complexity. Perhaps one example may be the Court's Integrated Services Program, or CISP, operating in Victoria, designed specifically to respond to offenders experiencing multiple forms of disadvantage. The CISP provides trained staff for initial assessment, individualised case management, and referral to supports such as drug and alcohol treatment, acquired brain injury services, disability and mental health services, accommodation and Koori liaison. In one anecdotal example from Victoria, a man in his 40s called Gary had been in and out of custody for minor offences his entire life. When, through this program, he was diagnosed for the first time with an intellectual disability, finally referred to support services that met his needs. Gary found employment and has not offended since, demonstrating that proactive approaches can reap real rewards. In fact, an independent evaluation revealed that offenders who use the program are significantly less likely to reoffend than other peers. Without a doubt, programs like these are achieving promising results. Just as Article 12 of the CRPD specifies, offenders are being supported in the exercise of their legal capacity, and through this are starting to break the cycle of disadvantage and offending. An example of the pragmatic ways in which we can support vulnerable people in the exercise of their autonomy. Violence and restrictive practices. This is just as important, of course, when people with disabilities are the victims in the criminal justice system, disbelieved or discredited, denied appropriate information or support, perhaps unable to communicate what has occurred, or dependent upon their offender for material or financial assistance. Australians with disabilities experience disproportionate rates of physical violence and abuse. In a disturbing example in 2009, staff members of a Queensland independent living facility were charged, and one was found guilty of assaulting and depriving disabled children of their liberty. Common practices, including tying children to the toilet, rubbing chili in their mouths, beating them with fly swatters on their genitals, removing prosthetic limbs, washing out residents' mouths with soap, hitting, humiliating and pulling hair. Upon sentencing, one of the former staff, the judge noted a culture of abuse flourished in the facility and permeated from the top down. It must be noted concerns of abuse at this facility were raised with the relevant authorities who were charged with protection vulnerable people as early as 1999. It wasn't until after 3 investigations and continued calls by local community members who convinced local police to reinvestigate complaints in 2003 that led to charges being laid. The assumption behind this kind of culture could arguably be that experiencing abuse is inherent to the condition of disability. In this way, behaviours considered a violation of rights in an able-bodied person, enforced isolation, widespread chemical restraint, or the neglect of personal hygiene are seen as almost inevitable in association with disability. The usual equation inverted, with the human being becoming an aberration and the violence becoming normal. This destructive paradigm could potentially have been addressed by recent reform, yet results have instead been worrying. As this audience may know, in 2006, the Honourable Justice W.J. Carter was commissioned to investigate and report on the use of restrictive practices on adults with intellectual or cognitive disability in services funded or operated by the Queensland Government. Recognising that the use of restrictive practices often acts as a trigger for further problems, central to Justice Carter's recommendations was the premise that restrictive practices were only to be employed as a last resort to manage the most dangerous behaviour. Emphasis was instead to be given to developing positive behaviour support plans which improved skills, individual skills in capacity, in turn reducing the challenging behaviours that prompt the use of restrictive practices in the first place. The foundations of Justice Carter's recommendations were promising, yet the Queensland Government's response was a legislative scheme establishing a legal basis for the use rather than the reduction and ultimate elimination of restrictive practices. Compliance-based rights-based rather than rights-based, the legislation is a lost opportunity, to say the very least, one which in many ways further entrenches the use of practices we know can have tragic and damaging effects. Thus, structural violence is once again perpetuated. Violation of the rights of people with disabilities, carefully cemented as part of the walls that fence them in. Where can we look for more promising signs? Certainly Victoria's Charter of Rights and Responsibilities suggests possibilities. The Victorian Mental Health Review Board recently holding that in the context of the Charter, forced therapeutic intervention can potentially constitute cruel, inhumane and degrading treatment where it is sufficiently severe. This is a positive, albeit limited example of a rights-based approach towards the repeated abuse of vulnerable individuals in facilities and services. There is, however, an epidemic of violence occurring in the wider community to which collectively we appear to have little answer. It is an appalling truth that women with disability, particularly an intellectual disability, are subjected to physical violence at higher rates, more frequently, for longer, by more perpetrators and in more ways than their able-bodied peers. Moreover, women with intellectual disability are less likely to report violence, to access support, to have their cases prosecuted, or to see any prosecution be successful. Just as the junction of disability and any other forms of marginalisation can be cemented by structural violence. The convergence of disability and gender is especially confounding. The violence a woman with disability experiences becoming doubly normalised. In short, the policy and service environment fail women with disability because violation of their rights is deemed unavoidable and insurmountable, perhaps when relative to other more achievable reform. It is important to note here that despite its broad definition of disability and discernible success in other areas, Australia's Federal Disability Discrimination Act has not yet been used in the context of violence against women with disabilities. Given that neither existing criminal justice mechanisms nor anti-discrimination measures are designed to address such intractable examples of structural violence, then we need to find other approaches. Again, the CRBD offers a useful guide. Article 16, for example, creates a positive obligation on estate parties to take all appropriate legislative, administrative, social, educational and other measures to protect persons with disability, both within and outside the home, from all forms of exploitation, violence and abuse, including their gender-based aspects. Further, it requires that states to do so by providing appropriate forms of gender and age-sensitive assistance and support on how to avoid, recognise and report instances of exploitation, violence and abuse, and by ensuring effective monitoring by independent authorities. The article goes on to determine that state parties shall put in place effective legislation and policies to ensure that instances of exploitation, violence and abuse against persons with disabilities are identified, investigated and, where appropriate, prosecuted. Article 16 alone is a sobering reminder of just how far we have to go to meet our collective ambitions. Clearly, these provisions require governments to do more than merely abstain from discrimination. Like our commitment to so many human rights instruments, however, they do not always translate into reality. What's more, I readily concede that human rights instruments are not particularly enforceable at the local or state court level. Nevertheless, they do offer a glimpse of how we might frame an argument, helping us reconfigure or lend further weight to our approach, explaining not that a person's impairment prevents them from accessing justice, but the structures that surround them do so. In this way, we stop asking for the law's benevolence and solicit genuine justice instead. By taking a rights approach, slowly, this strategy is gaining momentum. Certainly a rights-based approach is the basis of the Disability Discrimination Act, which over the last 20 years has nevertheless had an impact, particularly in areas such as public transport and accessible buildings, in part by using the concept of industry standards to create a positive obligation. In this way, reform is achieved through collective acknowledgement, even when ignited by individual complaint. As suggested above, the Victorian Charter of Rights and Responsibilities also offers a model, placing positive obligations on government agencies and decision makers to consider human rights, and on the Parliament to contemplate and account for human rights in the development of any legislation. In the first 5 years of its operation, it has already been used in a range of ways to achieve meaningful improvement in the lives of Victorians with disability. More recent examples on the national stage, however, are also promising. One can be found in the National Disability Insurance Scheme, which, following recommendations by the Productivity Commission, met with swift bipartisan support. Nonetheless, by huge community lobbying. The scheme's broad purpose is to restructure service provision so that instead of public money funding disability services, funds will go directly to individuals with disability who will in turn be assigned a caseworker to help them manage whatever needs they may have in terms of equipment, employment, access or payments. For the first time, the manner in which a person receives disability services will not vary depending on where they live, nor on the effectiveness of particular agencies. In this way, the NDIS positions people with disabilities as active and autonomous, rather than as passive recipients, and doing so acknowledges impairment as a normal part of the human condition. Similarly, the National Disability Strategy represents the first time all governments in Australia have committed to a unified national approach. Its priorities range from health and well-being to, most relevantly for today's purposes, rights protection, justice and legislation. Amongst other things, the strategy calls for people with disability to be safe from violence, exploitation and neglect, as well as for more effective responses from the criminal justice system to people with complex needs. Clearly, the strategy echoes the principles of the CRPD. Most important, however, is its ambition to lead a community-wide shift in attitudes, to entrench the rights approach to disability closer to home. The Queensland Government's Disability Plan 2014-19, enabling choices and opportunities. The vision of the Queensland Government is for people with disability to be enabled to have choices and share the opportunities that are available to all. Priority 6 of the Disability Plan aims to enhance mainstream services and facilities to enable genuine choice and participation in areas including education, employment, health and justice services and housing, by strengthening safeguards and enable equal and effective access to the justice systems as victims or offenders. To give effect to these noble ambitions, Queensland must develop a disability justice strategy. And in conclusion, from the global arena through the national sphere to the state level, there is recognition of the systemic challenges that exist and of the disabling effect they can have. Of equal importance is the recognition that the community has a positive obligation to enable people, rather than just maintain a polite, non-discriminatory distance, to see the person before homogenising the impairment. Clearly, change needs to occur in this and other areas. Gradually, however, we are seeing signs of a shift in attitudes, of an adjustment in direction, which acknowledges that all members of a community benefit when people of every kind of ability take their rightful place at its social and economic core. Members of this audience, of course, are concerned with hastening the pace in this regard by applying the global human rights approach to strategies in your local community. You are helping to challenge and perhaps dismantle those disabling structures. Perhaps the experiences of Marlon Noble, of Gray and of David may become a thing of the past. To paraphrase Eleanor Roosevelt, unless the places in which we live have meaning to human rights for each and every person, then our larger world will be impoverished. Thank you.